We are talking about the Ministry of Defense and Ministry of Public Security. Today it's a debate on the budget, and it's not to be confused with our admiration for the armed forces. I've been here listening to lots of speeches here, and our admiration for those who have sacrificed their lives to protect civilians is without doubt. Debates are about not looking at history, but debates are about, particularly budget debates are about looking at the future. And therefore, when we are looking at the future, there are many things that have been said in the debate, of which some things that have been said were to do with the human capital in all the forces versus technology, and that technology needs to be used. That's true of agriculture, it's true of the armed forces, it's true of anything. That technology and reducing human resources is the way forward. There was questions about the proper return on defense, using defense forces for civilian works. It's not just that they do the work, but it's also an issue for their dignity. There is issues about education and training the civilian population on defense matters. And the list goes on and on and on. And I'm not going to really go there. Instead of that, I wanted to talk about really you need defense, but you need unity in a country. And we heard some of the speakers talk about that too. It's about the rule of law being the biggest defense a small island country like us could have. I heard the Honourable MP Namal Rajapaksa on the 20th of November come here and refer to a verdict given by the Sri Lanka Supreme Court, saying he questioned the right of the petitioners to challenge government policy in the court. And I think that was really hilarious to hear that. The verdict that was given a week ago in the Sri Lankan courts was a holistic verdict. It is the most important judgment that has been given since the 1978 constitution in this country. The Economy Next online report of April 4th, 2021 quotes Dr. P.B. Jayasundara as saying, President Gotabaya Rajapaksa knew revenue will be lost by tax cuts, but he considered it an investment, and an 8% tax rate slashed from 15% will remain unchanged for 15 years, he said. Dr. Nandalal Veerasinghe declared much earlier in May and in August again that the government slashed taxes regardless of IMF advice and disregarded central bank warning of the urgent need to seek IMF assistance. Now we all know the consequences. Rampant inflation, interest rates sky high, exchange rate completely out of control. FX reserves go from $7.6 billion to $155 million in August 2021. So the question the petitioners took to court was, who is actually responsible for this? So Chief Justice Jayanta Jayasuriya, Justices Bhuvanika Alvihare, Justices Vijita Malalgoda, Justice Murdu Fernando, and Justice Priyantha Jayawardena declared a judgment on a 4-1 verdict. They brought two cases from petitioners together, SCFR number 212/2022, SCFR number 195/2022, and they heard it together. In June 22, the fundamental rights petitions were filed in the Supreme Court on who is responsible for the current economic crisis. Former President Gotabaya Rajapaksa, former Prime Minister Mahinda Rajapaksa, former Finance Minister Basil Rajapaksa, former Central Bank Governor Nibad Cabral, former Secretary of the Treasury Sara Artigala were among 13 respondents to this case. The petition listed the reduction in government revenue, failure to reverse illegal taxes, failure to take remedial measures immediately, the devaluation of the Sri Lankan rupee, sovereign debt going sky high, not being able to reduce, the refusal to seek the assistance of the IMF until the crisis has exacerbated. So the petitioners made it absolutely clear that they do not challenge the policy of government in these proceedings. It was sent to court, and the judgment is there running into 200 and something pages. The conduct impinged in these proceedings includes illegal, arbitrary, unreasonable and capricious executive and administrative actions. Such actions and or inactions arise from the implementation of arbitrary and or capricious decisions by the executive and the administration of government. It impinged on and breached the public trust reposed in them. Acute shortages of fuel, gas, food, medicine, prolonged power cuts also followed. Long queues for fuel, gas, hardships to the entire society led to many deaths. And this is why these people went to court in the public interest. There was a breakdown, ultimately a collapse of public order and complete undermining of the rule of law. That is why pushed out a legally elected president had to flee the country because of that and subsequently only had to resign. Therefore, the judgment was a landmark judgment. The Supreme Court on November 14 held that the former President Gotabaya Rajapaksa, former Prime Minister Mahinda Rajapaksa, former Finance Minister Basil Rajapaksa, former governors of the Central Bank Professor W.D. Lakshman and Ajit Nivad Cabral, former Secretary to the Treasurer S.R. Artigala, and many others, including Dr. P.B. Jayasundara, violated the public trust and breached Article 12(1) of the Constitution in the administration of the economy, leading to the economic crisis. Now we have some lessons in this, Mr. Chairman. The lessons are: public officers have a responsibility to discharge their duties in the best interest of the public. Respondents were bestowed high power to uphold public trust, that includes all of us in this chamber, and were duty-bound to discharge duties according to the directives of the Constitution. Respondents cannot shirk responsibility by merely stating the decisions they took were policy decisions. It is clear that they did not act and take all measures to remedy the situation in the public interest. The public trust reposed in respondents was not a higher one, and it's bestowed on all public officers, and therefore respondents were obliged to act in a responsible manner. Actions, omissions, decisions and conduct of respondents directly contributed to the economic crisis. So there's a right to equity of the directive principles, which guarantees protection from arbitrary exercise of power. It requires the state authorities to ensure that their conduct doesn't breach the trust and that public resources placed in their custody are protected and preserved to exhaust and not used for political and personal benefit. Exercise of discretionary power should be guided by the directive principles recognized by the Constitution. The rule of law is not only rights and equality. The rule of law is about functionality and efficiency for sustainable economic growth. Merely because the decisions are contained with economic policy, that doesn't mean that the court has no jurisdiction over that. So right to equality is guaranteed by the Constitution in 12(1). All persons are equal before the law and entitled to equal protection of the law. Article 27(1) of the Constitution requires the President and the Cabinet of Ministers in the governance of Sri Lanka to be guided by the directive principles stated in the law. This is what actually has failed. And therefore, we have the questions that are being asked. The judgment underscores that no one is above the law. Just because a verdict comes against a member of parliament, somebody sitting here, we are no different. It can be the president of the country. He has immunity only while he holds office. He can't beat his wife or murder his wife and then think that he can escape from it. Nor can any public servant. That's only for a period of time. The immunity goes and then they are responsible. The judgment now clearly states that those named have breached the public trust. It raises the question as to how they could remain to represent the public. It's natural that that should be asked. Civilian organizations go further and say, how could they be faulted to continue to receive public benefits and continue to be in this house? That's another question, Mr. Chairman, that should be posed. Those who have held the highest office in this country, whether it is actually suitable, particularly for those who have become presidents of this country, to come back into this chamber. We all know that once you have held the highest office, whether it's in the armed forces, it's the Navy, police, Air Force, or whether it's in a public quoted company. You don't make your way back into those institutions again. So there are questions of law, and there are also questions of ethics that are being raised. And therefore, we must not use our privilege in Parliament to undermine the verdicts that are given by the Supreme Court of the country just because it's again members of Parliament.